Today we will be talking about the enforcement program for the Division of Water Rights. Prior to 2005, there were no direct enforcement authorities given the state engineer. Violations were addressed by criminal complaints filed in civil court, followed by civil litigation, and without civil litigation, there were no penalties for violations. In 2005, Sections 73-2-25 through 27 were adopted to provide the state engineer with enforcement powers. These statutes also defined the criminal penalties and outlined any administrative penalties associated with these violations. Additionally, Administrative Rules R655-14 was adopted to detail procedures for enforcement proceedings. An enforcement action is authorized when a water user is diverting, impounding, or using water for which no water right has been established, or they are diverting, impounding, or using water in violation of an existing water right. Examples of violating an existing right are unauthorized changes in points of diversion, places of use, or nature of use. Also, exceeding the diversion limit of a right is a violation that is enforceable. An enforcement action is also authorized when a water user fails to comply with a requirement to install or repair head gates or measuring devices, or when the water user fails to comply with an order regarding dam safety or natural stream channel alterations. An enforcement action is not authorized when more than 12 months have passed since the violation ended. The state engineer cannot enforce private party agreements between water users or internal disputes within water or irrigation companies. An enforcement action is also not authorized when a complaint involves right-of-way or trespass violations, even though it may involve a water-related structure such as a canal or head gate. After investigating potential violations, efforts are made to try to resolve violations informally. If those efforts fail, an enforcement action begins when the state engineer issues an initial order. That order will include a description of the violation, a notice of potential penalties, and notice that each day's violation can be treated as a separate violation. Violators may be fined up to $5,000 for each knowing violation, or $1,000 for each violation that is committed unknowingly. Water users may be required to replace up to 200% of the water taken without authorization. The respondent can also be required to cover the state engineer's costs incurred by investigating and stopping the violation. Some considerations made before actually imposing the fine or ordering replacement could include the value or quantity of water taken without authorization, the gravity of the violation, including the economic injury or impact to other water users. Also, the state engineer considers whether the person subject to penalties attempted to comply with the order, and what the economic benefit was to the violator. Goals of the enforcement program include encouraging public participation in reporting potential illegal use. The public can report potential illegal use by filling a water rights enforcement referral form with our office. That form is located under Applications and Records section on our homepage within Miscellaneous Forms. The majority of our enforcement is a result of neighbors or other residents reporting what they think could potentially be illegal use. A resolution of first-time offenses are usually handled informally. If violations are considered egregious, violators may still be considered for formal enforcement. Any second offenses will result in an enforcement action. Remember, while the state engineer tries to resolve issues informally, that is no excuse to violate the law. We may walk softly, but we still carry a big stick.